My name is David Newell. I'm a judge on the Court of Criminal Appeals, Place 9. Not as familiar with the Anthony Graves story, and not to sort of cast aspersions on any of the prosecutors, but what happens is, what I saw from those cases, or what I see from those cases, is that the prosecutors are firmly convinced that they have the right person. And sometimes when they are firmly and convinced that they have this person, they tend to overlook other pieces of evidence that might take them down a different path. There's just this certainty that they have the right guy. And then once you've done that, there's a real temptation to sort of look only for the things that confirm that you have the right person, that you have the person that you're looking at, not necessarily things that would lead you in another direction. One of the things that I saw, a documentary I saw during law school, was a documentary called The Thin Blue Line. And my response to seeing that, which was a case where a man was wrongfully convicted and he was on death row, my thought is that the system needs good people to try and make sure that they make decisions so these things don't happen. That's true. It is it is one of the vagaries of the system, is that once you're into the formal aspects of it, it is much harder to get everyone together to try and sort of figure out and work collaboratively to solve something. And you're just dealing with one case that's in front of you, it's adversarial. And so there's certain barriers that you just are not able to overcome because the person is trying to advocate for a position contrary to your position. But one of the things that's nice also about being a prosecutor, one of the reasons why I always wanted to be a prosecutor too, was that our duty was never to seek a conviction. It was always to see the justice is done. And there's a great deal of discretion that prosecutors have to just simply dismiss a case. And so that is a certain amount of, it's a great responsibility, but it's also a certain amount of freedom for prosecutors to say and try and correct that error when they see it. And prosecutors dismiss cases a lot. I was never afraid to dismiss a case if I thought. I dismissed a case once in the middle of trial where the witness had lost credibility for me, and I didn't think that we could proceed in good faith, and so I dismissed the case in the middle of trial. That's a lot of responsibility and it's a lot of power, and it can help to overcome some of those things that you're dealing with. But if you're dealing with a prosecutor that is or if you're dealing with, I don't want to single out prosecutors for being bad or anything, but if you're dealing with a person that is just so completely convinced that they have the right person and they're unwilling to consider alternative things and they don't listen to the rabbit trails that a defense attorney puts out, it can stymie that process. It can be very difficult. If you're innocent, ideally you would entrust your defense attorney to find out evidence and find the things that they can point to suggest that you're innocent so they can bring it forward. Bill Allison in the Michael Morton case did a fantastic job of doing that, even preserving things like he did not know that the technology was available that would later exonerate at Michael Morton. He did not, but he preserved the idea and has been complaining, you need to get this, you need to make sure that this bandana is tested. That's what a good attorney does, is that they, even when they recognize that there are shortcomings in, say, the system or their case, or the science hasn't caught up to their ideas, they make sure to preserve that for their clients. And ideally, that's what a defendant would have to rely on his attorney to do something like that. And I mean, that's one of the reasons why ineffective assistance of counsel claims are troubling in the system, is because that's a situation where, and the review of ineffective assistance claims was never really meant to make counsel better. It was always meant to see if, looking at the proceedings, the defendant received a fair trial. But that said, if that's the analysis that courts are engaging in, there's not really a lot of, there's not as many places where you can point to say, well, this is what effective counsel should do. This is how to be effective counsel. It's really more how not to be ineffective. It's not how to be the best attorney you could possibly be. And that comes through a lot of education. And the Texas Criminal Defense Lawyers Association and a lot of criminal defense lawyers associations do a very good job of emphasizing the need to educate attorneys so that they are abreast of changes in forensic science and how to zealously represent their client, and how that they can convey how that they can best make the innocence case. But yeah, it is certainly not surprising. I think anyone in a situation where they were wrongfully accused would absolutely want to shout from the rooftops, I'm innocent, I'm innocent, I can't believe this is happening to me. But the bigger thing that you see, the bigger thing I think that you see is actually more along the lines of the prosecutors just not even aware that it's exculpatory at the time they look at it. By and large, that's where many of the cases are, or even worse. Police don't recognize it as exculpatory evidence, so they never give it to the prosecutor in the first place. There's a case called Kyles versus Whitney that recognizes that the duty to turn over Brady evidence isn't just on the prosecutor, it extends to everyone in the prosecutor's team. And that means the police need to know how to find Brady evidence and turn it over, because the prosecutor is going to be tagged for having not turned over this evidence, even if he's not aware of it, because the police officer was aware of it and he just never gave it to him. And that's sort of the thing that I think people don't know, and I think that's something that police officers aren't aware of. Once a police officer or a prosecutor or somebody, or a defense attorney too, has an idea that they know who did it or what have you, they tend to not look at competing evidence, and they just won't even recognize it. There's a great psychological test that's now being shown to prosecutors. I know because I've seen it at prosecutor training, where it's the gorilla in the room, or the gorilla in the middle or something. There's a book on it where basically they tell you as part of the test, look for how many passes people are having when they're passing this ball back and forth. And when you take the test, you focus so much on the passing, you don't notice that a person in a gorilla suit comes and stands in between this ring of people passing the ball, stands there, and then leaves. And no one notices it. And that's sort of the thing, is that in hindsight, everyone will go, there's a gorilla. If you know to look for the gorilla, you're going to see this gorilla and you're going to say, that's a gorilla there. You're going to know something's wrong. But when you're dealing with a situation in a heightened case where you are investigating a case or you are prosecuting a case, you may not see that gorilla because you are so convinced that you have the facts, and these facts will point you to that. I mean, there is a case, it turned out to be wrong, but they had evidence that they could use in order to convict Michael Morton. The problem was that there was a lot of evidence they didn't test simply because they were so convinced that the evidence they had painted this one picture that they completely ignored this other evidence. Had they done that, Michael Morton wouldn't have been found guilty. Had they focused on the bandana, or they focused on this other evidence, and they'd been open to these other alternative theories. But that's what happened, is that they were just so locked in their confirmation bias that they just couldn't see what was right in front of them.